My name is Don Jessup. I'm the owner of Silicon Valley Associates. And on your chairs, there's a little bit of information about us and who we are and what we're doing here. And then we've been doing some mindset performance workshops as well, and it's our latest flyer on that. And if you're interested in coming, they're free as well, and we'd love to have you here. And Roger Palmieri is an author and a motivational speaker and also a trainer. And he's unbelievable to listen to, and it'll change your life if you come and listen to him talk. But today, Guy Berry. When I first got into business 32 years ago, Guy's one of the only people that have been in it longer than me. There's a couple of you that are here. And I was a Guy Berry junkie. And groupie, that's right. Boy, we used to go to everything because I was 24 looking 18 and I was green in business. And I needed to have good information, and followed Guy for years, and I buy all of his tapes and listen to him because it keeps me up to date, because I got to keep 35 agents up to date and what we're doing. And he's the best at what he does in training. So there isn't much more to say other than that. Guy, why don't you just impart your wisdom?
Yeah, I have been in the biz a while. So I guess the question would be, what is this old guy with funny glasses and a bow tie going to tell you about contracts? I want to start by saying I'm not an attorney. I've sat out there like you do, because I am an active agent, and heard attorneys talk about the contracts, and I think at some level I sat there not really understanding and saying, well, it's easy for you because you're an attorney. I mean, I really had that mindset. And then I had the misfortune of starting to manage offices. I used to have hair, for example, and you agents made me lose it. But you don't get smarter being the manager, but you do get a lot of questions. 1,000 a day, right?
Yep.
What about this? What about this? What about this? And I realized I didn't know the answer either. And I also got the complaints. And I also got to talk to the attorneys and went, oh my God, that's what the contract says? So I just made a commitment to say, I've got to learn what this says if I'm going to do my job correctly. And here we are. 30-something years later, I'm still doing this. But I think it's even a bigger problem today because the courts have changed in that what they expect of you. Don didn't mention it, but one of the things I do besides being an active agent, I'm also what's called an expert witness. What that means is when you get sued, I get hired by an attorney to say, did you do your job? And I can tell you, the expectation of the public and of the courts is up here. Now, they don't take into account how completely ridiculous our licensing is. How many people agree with me that our licensing system is ridiculous? Right? Now, it used to be a couple of years ago you didn't have to take any classes until after you got your license, which I thought was really stupid. Now you have to take how many? Is my mic? Hello? This is how many? A couple, maybe?
Four.
You have to take 4 before you take your test?
4 or 5.
Yeah. And of course, that teaches you everything you need to know about real estate. How ridiculous is that? And then, then you go to a class to teach you how to pass the test, and then you get your license, and you now can sell what?
Property.
What?
Real estate. Real estate.
Commercial, raw land, subdivisions, high rises, I mean, how crazy is that? Right. Do you know any of that? No. A lot of you don't know how to do the residential part, let alone the other part. So, and is any of the training about contracts?
No.
Yeah, and yet, isn't this kind of the essence of the business? Because I can tell you, when litigation happens, you think anybody looks at this? Yeah, because this is the first thing you look at, because this is the agreement between the parties. And then the question is, the clients always say, nobody told me. And that's probably true at some level. Do you agree?
Yes.
Because how many of you actually explain the contract to your client? either you're shy or you didn't put your hand up, but the point is, I can tell you that in litigation, one of the things that happens, we're going to talk about that because I can bring my litigation experience in, and I've done 300 cases now, so I have a real good sense of what's going on out there. I can tell you the clients expect you to know this. Let me ask you a question to start. How many think the clients should know what they're signing when they sign the contract? But they should know what they're signing.
Absolutely. Yes.
How many think they do know what they're signing?
They don't.
Is that a problem?
Yeah.
There ought to be. And the problem is you can change that. So I'm going to challenge you today to try to raise the bar of your expectations because you're probably wanting to be a good agent. You're here. A lot of people aren't. So you want to be better at this. So set the bar that you say it's not okay with me that I don't know what the contract says. Because I can tell you there's an expectation legally that you do. Now, I get asked all the time during a trial, Mr. Berry, is it your opinion, by the way, that's what experts give is their opinions, is it your opinion that agents have a duty to explain the contract to the client? And I usually answer no. And they get a quizzical look in their face like, are you saying the agent doesn't have any duty? And I said, no. You asked me whether they have a duty to explain it. I said, I think they have a duty to make sure the client understands it. Is there a difference?
Yes.
So, because I could read you the contract, does that mean you know what it means? Have you ever had a situation where you said something and the other person didn't get it?
Anytime.
Like you married?
Like my husband.
Yeah. You have teenage kids? I mean, communication, we're in the communications business. But the point is, you have to explain this in such a way that they know what it means, not what it says. And this is exacerbated, I think, because we have so many immigrants to this country now and in the business that they're speaking a completely different language in a different culture, and you're trying to explain liquidated damage, and then they go, what? They don't know what it means. So I think your duty is much higher than it used to be. Because in the old days, when I came into business and Meredith came into business, were you a one-page day, one-page? Okay, she came in after I did. I was in the last. We had a one-page contract, and that much was blank. And if you wanted an inspection, you had to ask for it. If you wanted a repair, you had to ask for it. So that was a different world. Now we have this completely different mentality of what your expectations are. And I can tell you, as you sit there today, if you say, hey, I think I know the contract pretty well, you may be challenged to that, because during litigation, by the way, and trust me, if you sell enough houses, you will eventually be involved in some litigation. It just happens. The attorney's job on the other side is to beat you up. No matter what role you played, whether you were the buyer's agent, seller's agent, whatever, your job is to get beat up, because we have something called comparative negligence in California. What that means is the judge or the jury can allocate responsibility. They can blame the seller for not disclosing something 50%. And they can blame the listing agent 25% for not telling the seller they should have disclosed that. And then they're going to blame the buyer because he was warned in the buyer's advisory that he should check this out, and he didn't. And then they're going to blame the buyer's agent for not telling the buyer that they should do, and all the on it. So everybody's spread out. So what they want is that somebody, that you get a little bit of guilt, because the way comparative negligence work is that if you're in the case and you're contributed even 1% liability, if the other parties don't have any money, you get to pay. So guess who usually has E&O insurance? Us, right? So it's very common that the realtors get drug in just for that, and then they try to embarrass you to the jury so the jury doesn't like you. And one of the ways they can embarrass you is ask you what the contract says. Because it's very typical, they'll say, did you explain the contract to my client? And of course most agents would say, yes. Well, I was in a case in Santa Cruz, and that's what happened. The agent said yes. And he said, did you explain the whole contract to my client? And he said yes. He says, well, my client claims you didn't. So we have a dispute here about who's telling the truth. So why don't we do this? And he took a purchase contract and turned to paragraph 25, liquidated damages, and hands it to the agent and said, well, would you do this for me? would you explain liquidated damages paragraph to the jury the same way you explained it to my client? And then walked over and stood by the jury. How do you think the agent did?
Terrible.
Yeah, because first of all, you're nervous. I mean, imagine being on the stand with a microphone in your face and an attorney and a judge and 12 people with notepad looking at you. You don't do well. I used to be just scared up there. The agent did terribly. Just babbled, you know. And eventually the attorney said, would it be fair to say you really can't explain it? And the agent sheepishly said, well, I guess not. Was he done? No. The attorney wasn't done. Because then he got to say, what other parts of the contract did you not explain to my client? Now the agent's done. The old joke about put a fork in him, he's done. Because is he going to be trusted in the eyes of the jury? No. So nothing he says the rest of the trial is going to matter. That's what they do, guys. Attorneys are very good at what they do. Just like you guys are good at selling houses, they're good at being attorneys. So we don't want to be there. But if we get there, we better know what we're talking about. But see, I think too much of this industry spends a lot of time protecting ourselves. Probably half of our disclosure forms are not for the clients. Who are they for?
Us.
Yeah, to protect us. See, one of the things I've learned is if your client doesn't have a problem, you never have a lawsuit. So my focus is always about let's protect our clients. That way we'll never have a problem to come up. So if I'm a buyer's agent, then I want to protect my buyer from a listing agent. Now that goes to another thing that I do from time to time. I haven't done it in a while. I do some weekend classes for the public. Like I did a class at UC Berkeley for more than 10 years called Buyer Beware. You know, I was trying to take the public and scare them into saying you need a really good agent, you need a really good lender, and you need a really good home inspector. That's the way you probably can be protected. Then does everybody believe if the client would listen to us, they'd do better?
Yes.
Yeah, but they don't, do they? Why not?
They don't trust us.
Why should they? What have we done to earn any respect? But here's what's interesting. At my class that I've done for the public, I've done it at De Anza in West Valley and different places. The first thing I do is ask them, you guys are here for a reason. Then I'm going to tell you that it's about you having a really good real estate agent. What do you want your agent to do? Now here are pretty intelligent people. Wouldn't you guess that people that are going to UC Berkeley on the weekend probably got it from their publicity? So many of them would be Berkeley grads, which is some of the smartest people around to get in Berkeley. So you would assume they would know how to answer that question. In 10 years, I never got one answer other than, only got one answer. What do you think that was? What they want their agent to do for them.
Commission?
They never thought that far into it.
Trust. To be honest.
Huh?
You got cheap house.
Maybe. They didn't talk about negotiation. They didn't want negotiation skills. They didn't think of anything. It was one thing.
Trustworthy.
Find them a house. You see the problem? How many of you have ever lost a client? Anybody ever lost a client? Maybe I should have said, have you ever had a client? Because y'all didn't put your hands up. Why do you think you lost a client? Ever have your people never talk before, Don? That's kind of a miracle. Well, why did you lose the client? And don't say buyers are liars, because I think that's not true. Okay?
Different philosophies.
But you didn't find the right house.
You didn't find the house. It's that simple. You're attributing all kinds of stuff to it. You also didn't show them that you mattered. See, if their belief is that your job is to drive them around and look at houses, if you don't do that, can you see why they want to use somebody else? It's that simple. And yet we don't do any education in that direction. Now, somebody said earlier, they don't respect us. Did you guys see, I didn't bring a copy today, but Gallup did a poll a few years ago about what people thought about various industries, the respect level they had. You know, for ministers and doctors and nurses and firemen and politicians and realtors and you know. What do you think? How do you think we did on that poll? You know-
Second to the bottom.
Huh?
Probably second to the bottom. Michael Clark.
We were down with car salesmen and politicians. How bad is that?
Been that way for years.
It's been that way forever. In fact, only 3% of the survey, and this is Gallup's, this isn't some off the wall, some stupid survey company you never heard of, 3% held us highly in respect. 3%. Politicians were 2. And car salesmen were 3. How's that make you feel? See, I think you need to know that, because you're standing at an open house all pretty and dressed up and wearing cute shoes and all that, and they think you're this guy. What do you think maybe we need to do differently if that's who they think we are when they walk through the door? Yeah. Now, let me ask you this. By the way, the rest of the survey said this was high regard, this was good, okay? So it was like a total of 20% held us in either good regard or higher. That's 1 out of 5, right? What do you think of this industry? What do you think of other agents?
Getting worse.
Do you highly respect all of them?
No.
So why would the public not have the same belief you do? So let's not be angry at them. Let's understand where they're coming from, and to find out to say, hey, we've earned this. Don't you agree? Have we earned the disrespect of the world? Yeah. The part of it's our licensing. Do you agree? It's too damn easy to get a license. I don't want to pick on new agents, but it isn't fair to what they do, and all of a sudden they let you loose. So here's the concern I have. Have you guys ever heard of the 80-20 rule?
Yeah.
Okay, you know, 20%, here it is if you don't. 20% of people are supposed to be above average, 20% are below average, leaving 60% which are average. Is that right? If we add these together, we get 80% or 8 out of 10. Our average or worse. What do you think of that? 8 out of 10? Isn't that, when you look at it that way, how shocking is that? I mean, that applies to what? Home inspectors and lenders and
The whole industry.
yeah, the whole industry. And so the point is, do you want to be in this category? In fact, some people told me they thought this was too high. Do you think 1 out of every 5 agents is a top agent?
No.
I think that's too high. You agree?
Yep.
So, the clients don't know this. So why I'm going this, what the heck's this got to do with contracts? It's got everything to do with contracts, because it's got to do with respect. How do you get respect?
Demonstrating knowledge.
Okay? Don't you have to earn it? You get it automatic. If we were a doctor or a nurse in this same survey where they're up around 60 or 70%, they get automatic respect. Do you agree?
Yes.
We have to earn it. And the way you're going to earn it is show them that you're not these guys. The other end of this spectrum. You're not this group. Their experience in the world is this. 8 out of 10 of the agents they met are average or worse. So the only way you're going to get their respect is to have them learn that you do something differently or something you know that they don't know. See, the way our culture works, if something is really, really hard and we can't do it, we hire other people to do it and we listen and respect them. Do you agree? I quit doing my own dentistry, by the way. Why don't I do it myself? Because I don't know how. How many people fix their own cars? How many of the ladies have somebody else do their hair? Nobody in this whole room?
Oh, yeah.
Why don't you do it yourself?
Not as good as,
They're not as good at it. They're better at it, right? They know stuff you don't know. They know how to do color. They know how to do this. They know how to do that. The point is, that's why you use them. And you know what's interesting too? You're willing to pay for it. You're willing to pay a lot for it. True? And you feel good when you leave, right? And I got a little pedicure and a manicure and a... So what's the most that a lady in the room pays for a haircut? Don't ask guys because we're cheap, okay? What's the highest? What's the highest? 40 or 50? Is that the highest?
no, they're higher. Depends on where you go.
If you're in downtown Los Gatos, is it going to be $100?
More.
Okay. So why is that? That some woman is willing to pay $100 for a haircut when Supercuts exist for $12. So I don't want to ever hear you or tell Don about some client being cheap. People will pay for stuff they respect, but you've got to earn it. They have to understand that you have this expertise that nobody else has. And the point is, this group is so bad at what they do, it should be easy to prove to the client that you're not them. How many people are brand new agents? Okay, just one? Can we blame her for this survey?
No.
She's got a great story to tell. You agree? Because it's not her. That was them. Because one of the things I always do when I meet a client is ask them what they think of agents. And the ones that are honest are not very nice about it. Because why should we ask them that question?
It's really going to help, obviously, I think.
Find out where they're coming from, right?
Exactly.
Yeah, I mean, they're somewhere in this spectrum about what their belief is. We're all slime balls, or that, you know, I really love real estate agents. But the point is, this will give you a chance to show some things. And I'm going to suggest that what you can talk about is this. I've got to show the client that I'm not one of the bad guys. And I'm going to show them that with technical skills, because they don't care about... Look, if your job is showing houses, how hard is that?
It's easy.
In fact, do they even need us to show houses?
No, they got internet.
See, in the old days, we used to hide the ball and you had to come to us. Now the only reason they come to you is because you have a key. But then they'll do everything they can to go around that by going directly to open houses or calling the list agent direct or whatever, because they don't think you're important. Huh? Yeah. But does it make sense that if the client really understood real estate, they wouldn't do that? If the clients really understood real estate, would they actually ever do a dual agency?
No.
Never. See, do you guys get that? They would never do a dual agency. I don't care if they were getting a 1 point kickback or whatever it was. Because why?
That's liability.
Well, no one protect them.
There's no one to protect them.
Right, no.
The point is, the seller and the buyer have opposite goals. The seller wants the highest price, the buyer wants the lowest price. So how in the heck can you represent both people and fight for them to get what they want? That's what a fiduciary does. Fiduciary is a gladiator. They're not some paperwork person. My job is to win for my buyer. I don't care if it says win-win or not. I'm supposed to win what my client wants. He wants the lowest price. My seller wants to do as is. The buyer wants a brand new house. Right? Mm-hmm. The seller wants you to close in 5 days, and the buyer wants 10 years to get the contingencies removed. Like, isn't that true? They're opposites. So you've got to understand that they have different goals. And if I can convince the buyer that I'm different, which is the hardest job you have, by the way. I mean, how many clients do you think know more than one agent?
Everybody. Everybody.
Yeah. It's like that joke. Did you ever hear that joke about the highway patrol stops a car on the highway and says, "Can I see your real estate license?" And the lady says, do you mean my driver's license? She says, no, everybody doesn't have a driver's license. Don't you ever feel that way?
Yeah.
So the point is, how do you differentiate yourself? Because you're not going to get loyalty. You get loyalty by what? Earning it. Unless you show them that you're not the average agent, which they hate anyway. 8 out of 10 agents are average or worse. In fact, this probably should be 10%. Do you agree?
Yeah.
You consider that we have, what, 6,000 or 8,000 agents in our county? What percentage of those do you think are the top agents? Well-trained, experienced, knowledgeable? Very small amount.
3% maybe.
Probably. Yeah, I'm probably being optimistic up here. So the point is, if you did your job right and you were able to convince them you weren't them, do you see how that would give you an advantage? And then if they will actually listen to you because they do respect you, they'll win, and when they win, they'll give you referrals. That's why the business is so hard, because we don't do anything about that. Now, if the public doesn't know what we do, whose fault is that?
It's our own.
It's our own fault. Do you agree?
Yeah.
And you're never going to get anything from our boards or from CAR or NAR, which says, here's what a really good agent looks like. Why do you think that is? Couldn't they run an ad and say that? Yeah. See, if they set up a standard for what a good agent is, that would be used in every lawsuit. So CAR will never say what it should look like, because they're not out there for the public. Do you think CAR's on the public side?
No.
Whose side are they on? Their job is to protect us. That's like the medical industry. No, they're not out. They're protecting doctors, not us. So I'm going to suggest that one of the things we could do is use the knowledge that we have of the contract as the basis for showing clients we're not the average agent. Now, do clients want to ever talk about the contract? No.
really.
They don't even want to talk about it when they found a house, let alone before they find a house. They just don't care. Why do you think they don't care?
It's not their goal at that point.
Yeah, they're thinking about houses. Do they maybe need to be protected?
Oh, yes. Of course.
Because here's what I'm going to suggest to you. Your job is not showing houses. And I'm going to tell the client up front, I want you to understand before we start this meeting, my job is not to find you a house. They're going to go, what? Then what are you here for? I'm glad you asked. Then I get to go into my story. Here's what your job is. Is that a better job than driving people around?
Yes.
Because isn't that why they need you? I want to make sure my buyer never has to sue anybody because the house isn't what they thought they were going to buy. I want to make sure my seller never gets sued by a buyer because we're going to make sure we make full disclosure. In California, you can sue someone 3 years from discovery of the problem, not 3 years from close of escrow. How long is that, by the way?
Wow.
How long is 3 years from discovery? Is that scary? You think our sellers know that? I remember a few years back I was in a case where a seller got sued like 5 or 6 years after close of escrow, and they were an older couple, had retired, took the money, bought a retirement home in Lake Tahoe, and all of a sudden here they are now. They were probably in their 80s, early 80s, driving down for this stupid lawsuit, and everybody was doing, and the only people smiling were the lawyers. So this is what I'm going to tell the clients my job is I'm going to make sure they understand why this contract is 12 pages long instead of 1 page long, because there's a lot of stuff in here to protect the buyer. And I'm going to talk about these things, and the problem is the clients many times when I'm talking about this go, well, this is complicated. See, the ultimate home run that you're going to get when you meet with a client up front, and by the way, that's where I'm going with this, that you should have the discipline to never take a buyer out to show them property until they've sat down in front of you and had a one-on-one meeting. That takes discipline. to go show them houses. So we follow the stereotype of what they think our job is. What if I tell them that's not my job? I'll take you to see houses. You see, that's a different conversation. I mean, I always see, I say that and clients go, I don't understand. They think that's what we do. And if they judge the way you show houses based on the way you drive, that's not going to show up too good. You ever see a realtor drive? They're looking at maps and driving and looking at it. That's why we don't kill people. That's why you probably have to have. Are they all additionally insured on your?
Yes.
Yeah. Do you guys even know what that means?
Yes.
What do you think that is? Because you got clients in your car showing houses, he gets sued when you have the wreck, right? So here's what I'm going to suggest. I'm going to suggest that we're going to have this sit-down meeting with clients, and we're going to talk about technical things. And if at the end of the meeting they say this to you, I didn't know it was this complicated, you've just hit a home run. Because if they think it's complicated, do they need you now?
Yes, they do.
Here's the secret, guys. That's the secret. I can tell you, in the last 10 years, I have never lost a buyer I sat down with. I can't say proud of that when I didn't have the discipline to do that. I lost them all the time, just like you do. And the good news is, if they don't want to sit down, guess what? It's okay, fine. I didn't waste my time. Because we have all wasted our time. How many people have you driven agents around and around and around, buyers around and around and around, they never bought anything? Right?
A long time ago.
I call that the mortuary close. That's where you put a buyer in your car and you drive around, either you die or they die. We've all done that. It's a waste of time, it's stupid. So let's find out if they're real, otherwise why work them? Because here, see, the first thing you need to do is when you sit down with them, is find out whether you like them.
Why not? That's
How important is that? I mean, do you guys know anything about personality profiles and stuff? You have different personality types. You just automatically attracted to them or you're repulsed by them. And the point is, if I don't like the client, how many people have ever had a client you didn't like? How did that work? They hated you too. Are they going to listen to you if they don't like you?
No.
No, so the point is it's stupid. It's a stupid thing to do. It's a waste of time. And I'm going to suggest that's one of the first things we need to find out. And I say to them, let's first of all, we're going to talk about whether we can work together. Which implies what? I may not work with them. They need to understand this is a mutual thing going on here. I don't have to work with you if you're an idiot. But agents don't talk like that. We talk in a subservient role. We should be here. We're a consultant. We know more about real estate than they do. So the point is they either need us or they don't. And if they don't like us, fine. Mike Ferry has a joke. It's really not a joke, but it's a great idea. He says, if you have a client you meet and you don't like them, think of someone in your office you don't like, referring to them, they'll probably love each other. I mean, that's kind of a joke, but do you think it's probably true?
very true. Very.
Yeah. Why waste our time? I've had a couple of escrows in my life where I had the clients I didn't like, and it was horrible. It's like a bad marriage or something. Really, it's just you're stuck with this person and you can't get out of it. You know. I did fire a client once. Everybody ever do that? That's the greatest feeling in the world, right?
How about your best friend?
Huh?
How about your best friend?
Oh, that's really hard. Yeah. Yeah, friends is a whole other story about how that can be a problem because we get sloppy on them. See, I'm going to suggest that meeting is so critical. But even before that, we need to capture clients. One of the most common places we capture clients is open houses. Do you agree?
Yeah.
That's where buyers are. They're looking around. What are we trained to say at open houses? You've all taken classes. I'm sure you have them here in other offices. Here's what you do at an open house. What are you supposed to say after, hi? What do you say?
I'm so-and-so, and this is who I work with.
Okay. Okay. None of your business. Okay.
Do you have an agent?
Okay. How about that one?
Yes.
We're all trained to say that, right? Do they tell us the truth?
No.
Well, quit asking the stupid question then. Does it matter if they have an agent? You know why?
They don't like it.
You just assume they like them because they're their agent? Most of them are down here. Do you agree?
Yeah, and that's why they're out looking on their own.
Yeah. You ever been in an open house and the person says they have an agent and your property, this is going back, where property's actually been on the market a month? The client just found out about it? Where's your agent been? This has been on the market a month. What are you out looking? I mean, I feel that way, don't you? So the point is, I think it's a waste of time, some of the things we train you to say. Are you from the neighborhood, or how long you've been looking, and all that stuff. I feel that way, the same way you feel when you go to a car dealer. How many people love that experience? We hate it. Why? They're trying to sell you something. You know that. How many people love to be sold stuff? I'll come knock on your door tonight with a bag of something at 7:30. Hi. We don't like to be sold stuff, right? And that's why they're staying with. That's why when they come out of an open house, instead of saying, "Where's the listing agent so I can find out what I need to know about it?" What do? "We're just looking. We're just looking. Don't come near me." Is that true?
Yes.
Because why? They think your job is finding houses. You see that? It's that clear. What if I said something different and the buyer comes through the open house and I have a copy of the car contract and I also have a copy of the PRDAS contract? Why would I have both of them? I don't know which one I'm going to use yet. Do you agree?
Yes.
And what if I said, by the way, Mr. and Mrs. Buyer, I know you're just looking. Why would I say that?
He answered there.
Just to be disarming.
Yeah, I'm disarming, and the point is it's okay to just be looking, so you don't have to say it again, Mr. Buyer, because if you say it again, I'll think there's an echo in the room or something. It'd be stupid to say it again. So I'm going to say, I know you're just looking, but by the way, is this the first open house you've been to? And the answer is going to be no. So you've been through some open houses. So has anybody, by the way, spoken to you about when and if you do find a house, do you realize you're going to have to sign a pretty extensive, kind of scary purchase contract? By the way, what decision have you made about whether you're going to use PRDS or car? They're going to say what? What about arbitration? Have you made a decision about arbitration yet? What about pest control clearance? You can do section 1, section 2, or both. Or what do you think the client would be saying at that point? Huh? Have I differentiated myself? Then I get to say what? Well, I'm surprised. I thought agents would be mentioning this. But you can see how important this is. One of the things that makes me different, I can go into my story, right? And I get together with a selective number of clients that we like to work together, and I sit down and go over these issues with you, but I don't go over the contract, I go over what's going to happen. That's the phrase I use, by the way. People don't care about the contract, they do care about what's going to happen, what decisions have to be made. If I try to close them for that meeting, and if they say no, what do I say? Survey says, wrong answer, I'm done. Does that make sense? I haven't wasted myself or my time, but the people that will listen and will sit down with me, if they get in front of me, I've got them. Because I am going to talk about all these issues, and I'm going to talk about the horror stories, and I'm going to talk about all the things that can go wrong if their agent's poor. Does that make sense?
Yes.
So at this meeting, I'm going to talk about, do you think, let me give you a good example. In this market, are there any deals out there?
No.
I haven't seen many. We've had deals in our office that's just ridiculous. You know, the list price of $1.1 million, the agent comes in with an offer at $1.3 million non-contingent, and it sells for $1.5 million. Does that make any sense in the world?
No.
And yet you have some buyers that think they're going to lowball. Right? Because they've read in the paper, maybe you can make a deal. Or somebody said the buyer the other day said, I want to go look at foreclosures. What? Is REOs always a good deal? No, God, of course not. I mean, you know, when you get 14 offers on an REO, it's the same problem you have whether it's not. I mean, so the point is that client doesn't understand. Do you agree? So what if I do the first thing I want to do is to tell them, here's what the market is. Now, how would I do that without just blabbing it? Because they're not going to believe us. Because why? They don't trust us in the industry. What can I do to show them what the market's really like in their price range?
Actually,
Don, are any of these people real estate agents?
Supposed to be.
Supposed to be. I want to see your licenses. How would you prove to them quickly and easily what the market's like?
Inventory?
You run the MLS, listings, sold price,
Based on market.
days on market. You know, it sells within 7 days, and it's 110% or 98% or 99% or whatever of the average list price. So don't waste your time, Mr. Buyer, if you think you're going to come in 80% of market or 20% under market. I had an agent in Fremont. I did a class about 6 months ago, and he said, yeah, I wasted a lot of time with my client. I've written 10 offers so far. We haven't got one accepted. I'd have been embarrassed to say that. Can a buyer lose a couple of houses before they get trained? Yeah. But would you write 10 offers for anybody? Because how much work up front is made before they finally found a house to make an offer? He's probably been working a year. Is that client learning anything? No. What a waste of time. Do you agree? That's because he thinks his job is showing houses. So I want to find out where the client's coming from. Because if they want to be crazy people, at least let me have a little training, and if they're not willing to be trained, then I'm going to refer them to somebody else who has nothing else to do. So I want to find out where they're coming from. Do I want to find out what they think of agents? Wouldn't that help? What do you think? What's your experience been with agents? I'm going to tell them the truth. I don't think a lot about them anyway. You know, I usually show them my Gallup survey, by the way, and say I kind of agree with Gallup. There's probably only about 3 or 4% of them that are really top agents. And what's your experience been? And a lot of people tell me, well, they've had bad experience, or their mom had bad experience, or their boss had bad experience. So I get to do then what? I get to basically try to show them what the difference is. So the other thing I want to talk about is, do you think maybe they don't understand what an REO sale is really like?
they don't understand. No, they don't.
No.
They just think they're getting a deal.
Yeah, but maybe that's our job to tell them.
Absolutely.
You know, do you know, Mr. Buyer, that you're going to make an offer in an REO, and they're going to counter you with an addendum that comes back and takes away every right you have in the whole world?
Yeah, exactly.
Is that okay? Well, no, it's not okay. Well, that's the way it is. Do you want to buy an REO? And by the way, you're going to get countered verbally. So even though they say you got the house, we don't know because they're still showing it. The listing agent is trying to get a higher price, and the buyers love that. They hate that. Do you think they really understand short sales?
No.
If they did, they probably never buy one. Do you agree? So you're telling me, Mr. Buyer, you're going to sit here for 5 months, and at the end of 5 months, now if the market's gone up, the bank's going to decide the price is too low and counter you at the highest price, and then you won't get the deal. Is that okay with you? Is that true?
Oh, that's happening.
It's happening. So the point is, they don't know this stuff. But the point is, what am I trying to do? I'm trying to get in this meeting, having them realize you don't know anything, that's why you need me. But if I do enough of these things, hopefully they'll say, wow. Like I said, we know doctors know stuff we don't. That's why we let them do what they do. They don't know what realtors do. They think we so. So I'm going to have this meeting, and I'm going to talk about different parts of the contract based on who the client is, about issues they don't understand. Try to scare them into understanding they need somebody. That if it's not me, you need somebody. Do you agree?
Yes.
How long should this meeting take, by the way?
30 minutes?
30 minutes?
An hour?
I can't say my name in 30 minutes.
At least an hour.
The right answer is as long as it takes. One of my good friends up in Half Moon Bay said the longest meeting you had with a client, he does this religiously, by the way, and makes about $1 million every year, by the way, very, very top agent, said his longest meeting was 7 hours. They were talking, they liked each other, they got along, they decided it was now 5 o'clock, why don't you guys, we go get something to eat together? Then they came back. I mean, do you think he owned that client? Absolutely. So do you see, that's a different relationship than we have in most clients. We build a relationship. And if people like you, are they going to be more likely to work with you? See, that's the point. It's not about they found a house. Why is it, I lost a client once, I thought a really loyal client. And on Sunday, he couldn't go out and look at houses because he was going to a friend's barbecue that he worked with. And right across the street from the house where the barbecue was, there was an open house. And that's what he bought. My fault, not his. Not want to stop that by having this meeting. So here's what I want to do. One of the downsides of my great theory here is that you have to know what you're talking about in this meeting, by the way. Do you agree?
Yep.
No, because you can't just sit there and blab. You can't fake it. You have to talk about something they know. So I don't know what you guys know about real estate contracts. Anybody pretty comfortable with contract, by the way? Pretty knowledgeable? Okay. We'll find out, by the way. Because we're going to have a little test. True, false. It's about the car form. It's not about what could be done. It's what does the form say. So it's pretty basic. There's no trick questions. So we don't want to spend a lot of time on it because we're not going to turn them in. They're just going to be for talking points today. So if you get to a question, don't know the answer, guess at it. And then put a question mark behind it. So you don't sit and dwell on it because we really don't have that much time left. So can you help me pass these out? Okay, number 1 is false. Number 2 is false. Number 3 is what?
True.
It's false. Number 4 is
False.
false? It's false. Number 5 is true. How are we doing? Are you doing good? Number 6 is it's false. Number 7 is
True.
false. Number 8 is false. Are we doing any better? Anybody thinking about a career change? Number 9 is false. Number 10 is false. Number 11 is false. Number 12 is false. Number 13 is false. Now, if you got 14 and 15 wrong, probably should just drop your license on the counter as you leave. So I can tell you, they expect you to know what the contract says. And is that unreasonable?
No.
No.
No, I mean, if I take my car to a dealer and it says auto repair, I kind of assume that they know how to fix it. Sure, you understand that, ladies, when you go to a beauty parlor, that you expect them to know what you do with your hair and how to use color and whatever. They expect us to know this stuff. They don't know about our licensing. They don't know how stupid it is. So they just assume we know this stuff. Yeah. So there's an expectations on their part about who you should be. And number 15 is your commitment to yourself about being the best you can be. So unless you did okay on this, you know, you might question, maybe I don't know as much as I do know about it. Did anybody get them all right? Anybody get them all wrong? On average, it's about 50%, to be honest with you, which is really kind of pathetic.
Number 5 could,
Yeah, we're going to talk about each one individually. Number 5 is kind of a wake-up call for most of you. So why don't we go over these and talk about them a minute, because my goal is, if you remember, I want to talk to the client about stuff they don't know. So they go, oh my God, I need somebody to help me with this. So what about number 1? Why is that false? Anybody get that right?
Sign in before.
Okay.
Talk to them.
What?
It used to be where California said that anytime that you conduct yourself in more than a casual conversation regarding real estate, that you created an agency between yourself and the buyer or the seller.
That's correct, which means we're supposed to sign the agency form when? When we meet the client, not when we write the offer. And I can tell you, as simple as that is, I was embarrassed because I was defending an agent in another case in Santa Cruz, by the way, where the attorneys handed me the agency form. Here I am defending the agent on, they were accusing the agents of telling the buyer, by the way, which I knew this was a lie. They said the buyer walked up when they walked through this house and there was this roof and it was about a 30-year-old shake. They were all curled up and terrible. And see, the agent said, this is what the buyer claimed, the agent said, this looks like a good roof. Agents don't do that, right? That's not what we do a lot of stupid stuff, but we don't do that. So I didn't believe it. So I'm on this case defending this agent, and the attorney says, Mr. Berry, did you look at the file? And I said, yes, I did. He said, did you happen to see this form? And he hands me agency. And I knew I knew I was dead. Because he said, did you notice, Mr. Berry, that form was signed the very same day as the contract? And are you aware, Mr. Berry, that they showed property for about 6 months? So did the agent use this form properly? And so I'm trying to be cute, of course, defending my agent. I said, well, some agents do it that way. Is that true?
Yes.
Yeah, it's true. He said, well, is it just practice, different offices or areas, or is it the law, or what is it? I said, it's the law of California. Then he said, what's the law say? And I said, the agent's supposed to sign that. I said, so, a technical violation, but, I don't think it's that big a deal.
Can that be changed? Because I think it is nuts.
I agree with you, but the point is, it's the law. So, call your representative in Sacramento and see what kind of results you get, if they even take your phone call. I mean, this is something done at state level. So the point is, the attorney wasn't done with me. So he said, Mr. Berry, so the agent didn't do this correctly. Is that right? And this is a law in California, correct? So would you say it'd be fair to say that your agent broke the law? Now we're in a trial. Here's the jury. And I have to say, well, technically they did. And the judge said, Mr. Berry, would you answer the question? Right? Because I can't be kidding. It is a technical violation, in my opinion. So the point is, and he said, so what other laws did your agent break in this transaction, Mr. Berry? I mean, we were done. Nobody's going to believe that poor. And what did he do wrong? Nothing, really. Because the agency form's a joke. Because it doesn't do what the goal is, which is to explain agency. Somebody had a question?
I have a question. So does that agency expire? Let's say you have one
No.
from a year ago.
So that's all it is. Look at, this is only information. We're not deciding whether we're going to be a dual agent or a buyer's agent or a seller's agent. We're only saying, here's what the law says. And by the way, when you have a problem, sometimes we have agents tell me they have a problem having their buyers sign that because they're afraid they're somehow committing to something. You have to say to them, look, if you will not sign this, which proves only that I gave you this piece of paper and explained it, I have to leave. Which is true, by the way. It's only information. See, a disclosure, that's what this is information. Does it make it true? Is a disclosure always true? No. TDS is the seller's opinion of, a home inspection is the home inspector's opinion. That doesn't make it true. It just means here's what we think we understand it means. So they've got to sign it. If they won't sign it, you have a problem. Okay. Number 2. Who got that right? Okay, Rita, why is that right? Why is it false?
According to the contract, if we go to that page that has, you can check the HOA documents, you can provide it later time.
Okay?
Well, no, the
Wrong.
property owner needs
Okay,
to provide-
great answer, Rita, but wrong. Okay. You got it right for the wrong reason. Okay.
Yeah, the property owner needs to procure the documents and give those to the buyer.
This says the HOA has a duty to provide them. They do not. HOA has no duty to anybody except the seller. Why is that important to know?
Because the seller has to request the
The
document.
seller's the one that's got to get involved. Unlike a regular sale, sellers can kind of not even be here until we get the house sold. Is that the case in HOAs? No. The seller's got to be involved because some HOAs won't even deal with you, especially if you're a buyer. I just sold a property in Morgan Hill where they wouldn't even talk to me, and I was the listing agent, and I had a written statement from my seller saying Guy Berry represents me, and they said, we don't talk to agents. Property manager said that.
Yeah, wow. It's getting more
So we have a sale, and we had a pest control inspection, and like happens on older condos, they found some damage outside the unit. And we had an FHA buyer come in with a really good offer. Is that deal going to go?
No, not unless you can.
No, because the FHA requires a pest control clearance,
Right.
and the HOA, by the way, wouldn't talk to me, so our sellers, I had to communicate him what to say to the HOA, and they said, we don't change our maintenance and repair rules based on transactions, we do it based on a schedule.
Right.
So that deal was done, do you agree?
Yes.
So the seller says, this property's vacant, I got 2 houses, we've got to sell this thing, what can we do? So I suggested he call the HOA again and find out who their contractor was. Do HOAs have their own contractors?
Yes. Some.
Not in-house. You know, usually they hire outside people. So we found out who their contractor was. We called him and got a bid, and it was like $157, by the way, for this deck board that was eat up. So we called HOA back and said, what if we pay your contractor to do the work under your supervision? And they said, that's great. So we did that and closed. So did that client need me?
Yes. Yes.
You see, there's what we do, okay? That's what an agent does. But we don't know that. But HOAs can be very difficult, so we need to talk to our clients and understand to them, look, Mr. Buyer, you know, I may not be able to find out what the heck's going on because they won't talk to me. Is that true? And when should I have that conversation? Up front, when I'm having this meeting, I find that they're a condo buyer. One of the things I do with a condo buyer, the first thing I ask them is why. Because some people have the wrong idea about what moving into a condo is. They think what they're going to do is to not have any problems. But they control your life, right? They're going to tell you where to park. They're going to tell you whether you can wash your car. They're going to tell you where your teenage kid that now is in college, that comes home for the summer, where he's going to park or not park.
Or if you can even be there.
Or if he can be there without permission. Because some say you can't have any adults in the property without notice, and they can only stay so many months. I mean, all these issues, have the buyers ever thought about that thing?
No, they haven't.
I think Jackie Berry, I don't know if you know who Jackie Berry is, this expert. Have you had her in here?
Yeah.
Because she's fabulous. Jackie tells this story about that this lady buys this condo, moves in, finally at the end of the day she's all tired and says, I think I'll take my dog for a walk, and she walks outside, and here comes a lady walking who happens to be the property, not the property manager, the HOA president, and said, I don't think I met you. So they introduced each other, and she says, I hope that's a guest. Because they had a rule on the size of dogs, and this was a big dog. It wound up in litigation, by the way. Because the lady said, if I can't live here with this dog, I don't want to buy this property. Then the argument is, who should have told her about the HOA, and did she read the documents? And some people like their dogs more than their kids.
Yeah.
They're usually nicer. So this is an important question, guys. So if a client is going to sit in front of you as an HOA buyer, do you think we ought to talk to them about what the issues are? Yes. And talk about, do you know about reserves? Do you know about accrual accounting? Do you know what all that issue is? Because it's huge. Do you know what to do if the property is in litigation? What if it used to be in litigation? What do you ask? All those issues, you probably don't know that. But you better, because that's what your job is if this is what you do. What would a risk manager do? Does that make sense?
Yeah.
See, when you see yourself in this role, it changes completely what you talk about. Question in the back.
Yeah, regarding the homeowners association, that is, at what level is our responsibility to, I mean, to read the whole 350 pages and understand it and explain it and try to protect our our buyer.
If you were the risk manager, what would you do?
Well, read the whole thing.
Are you qualified to read it?
Not really.
See, there's the other question. Then maybe since you're not qualified, and you know that, see, I don't do roofs either. I don't do roof inspections. Why?
You're not qualified.
I'm not qualified. So I tell my client they should get a roof inspection. So maybe if you buy a condo, maybe I tell them that if you buy a condo, we're going to have a professional look at these documents because they're so important. And send them to Jackie Berry. Does that make sense? See, if you're not, why do you think we're responsible for the HOA docs, but we're not responsible for the pest control inspection?
We're responsible for all of it.
You're kind of responsible for all of it, but the point is you only have expertise at a certain level. See, I can read the HOA docs. If you can't, then you have to hire somebody to do that. Does that make sense? Because it's so critical. Because what's in there is going to go. I'll take a great example. I had a client who had some money. His kids all moved away. His wife had died, and he was by himself. And he said, "I just don't want to deal with yards and stuff anymore." And you know what his hobby was? Fixing cars.
Oh, wow.
Can you fix cars in a condo? No. They're not going to let you. They don't, sometimes you can't even put a disabled car in the garage if they're not registered. He always was tinkering on some car and doing stuff because he loved that stuff. But the point is, he couldn't live in a condo, even though he thought so. We had to sell him a house. So do you think we ought to tell him that up front? Because look, what is my goal here? Is my goal teaching them the contract? No. I'm trying to convince them they need me, that there are issues they haven't thought about. See where I'm going with this? That's why it's so important to know what the contract says. Somebody have a question? Did I answer your question?
No.
I don't think you have an absolute duty, but if you're not qualified to read the documents, then I think you have a duty to tell the client who does.
But then, excuse me, but then if you read them, then now you're just taking on the responsibility of having to explain them.
Right?
If you have to, and if you don't explain them correctly, then at that point,
Right.
I'm not an attorney, but it seems
Do we have a
to me it's liable right there.
Do we have a tough job?
Yes.
Absolutely. Remember what I said our goal was? To say I didn't realize it was this complicated?
Right.
Absolutely. It is absolutely. See, what you have is all the issues about selling a single family home and then overlap over that with a big pile of stuff about condos. Like I suggest that if you really knew all you need to know about condos, you'd either be an expert or you'll never want to sell another one if you did it right. But that's not the way we treat it. We treat it like, well, it's just another sale. So it's a question.
Guy, I'm Barry, and I'm sorry, I can't keep quiet at the same time. One thing I'd like to add about the HOA, and Jackie Berry, who I also use, and I think she's wonderful. But Jackie doesn't assume all the responsibility, if there's an issue. And besides the HOA documents, there can also be issues on the preliminary title report,
Yeah?
which I believe in my life that most agents don't even read.
No.
And I think that along with the HOA docs, the agent has to scour because there could be conditions in there. I actually had litigation with one of my agents that Jackie was involved in, and there was a condition in the prelim, and it was vague, and the issue was never pulled. And what it had to do with is there was a deed restriction that said that the lower floor of this condo complex, which was a conversion, had to be rentals. So my agent sold the condo, and she went to move in, and they told her, sorry, you can't move in because the whole first floor has to be a rental. That was a deal with the city. So my point is whether you have a data service or you're doing it yourself, you need to scour the preliminary title report, and anything that you don't understand or know what it is, you call your title officer and you have them pull that condition.
Yeah, I call that the backup documents. I mean, how many people have ever got a prelim report and you really don't understand number 4 and number 7? You just don't understand what they mean. So what should you do? You call title and say, would you send me those documents? Because I want to know what they say. I have a listing in East San Jose now off of Clayton Road, one of those up in the hills properties, and it has some kind of easement for the power company across the backyard. I didn't know what it was, so we ordered the documents, and it says what can and can't be done there. You can't put a pool in, you can't. And so most agents don't read the prelim, I think.
They don't know.
Yeah. See, you know when the title reps, any title reps here today? I want to say offend anybody. No, she's not a title rep. That's Kim. Title rep comes around. Yeah. I have used Kim for how long? 31 years. Okay, there you go. You know how title reps walk around?
Yeah.
Don't waste my time. Okay? I don't care if it's cup day or pen day or calendar day or some other stupid day they come around. When they come around, say, would you help me to know how to read a prelim? Or hold a class with the officer or something. Does that make sense? If they're not helping us, don't ask me for my business. Because why? Which is right in line with what we're talking about today. Why would I want an escrow salesperson not to say, hey, could I have your next escrow? Yeah, have they earned it? First of all, I don't know who the hell you are, first of all. Second of all, I don't know who your escrow officer is. That's the real product, right? And I've got somebody I work with now for a long time, so what is it you're going to do for me? And they usually go, what? And they run away when I say that. I'm not trying to be mean, I'm trying to teach them something about how helpless, but teaching you how to read the prelim is, thanks for bringing that up. HOA docs is a problem. You can learn this, by the way, because I did. Do you think that would be valuable if I was selling a condo to a client to know what the HOA docs say?
Oh,
Yeah. Again, as the risk manager, it isn't that my job. I want them to look, even if it isn't a big deal, I want them to think what? About me. That they need me. So I can look through HOA docs pretty quickly now. Now, I'm not going to read the CC&Rs that say you can't park in the guest parking or whatever. I think the client has some duty to do that. By the way, I sold a condo a couple of years ago. The rule in the guest parking was almost none. You know how most of them don't have enough. The rule is the first time, $1,000 fine.
Whoa.
Is that getting their attention? Because I had my client call and they said they let her off. First time, she had a guest. They had a rule that if you have a guest coming, you have to call the property manager and tell them they're coming and how long they're going to be there. Holy moly. It's like Nazis. Okay, number 3. Turn to the first page of the contract. The title of the contract. What does it say?
Single family.
How much more simple can it be? They put it on the front of it. I was on the PRDS Forms Committee for like 15 years. And there's always a joke in the Forms Committees, by the way, that you may not think is funny, but I think it's kind of funny. Somebody, at least once a year, will say, let's put that in the contract, that way agents will never see it. It says it right on the face of it. If you're selling an income property, you shouldn't use this form, and yet I've seen offers made on fourplexes and all kinds of income property on this form. What's missing? What would be missing from this form if you use this form instead of an income property form that should be something the buyer would want to know about?
Proration of rents, estoppel certificates.
Yeah, security deposits. Do I want to know who my tenants are? Do I want to know what the leases are? Do I have somebody that's maybe he's not paying full rent because he's in charge of the garbage cans or something. He sweeps who knows? The point is, none of that is in here. So legally, if you were the buyer's agent and wrote this offer, my seller would have no duty to give any of that to you, by the way. So use the income property form. This applies, by the way, to a duplex. In fact, I would even argue that maybe if we have a single family home and the tenant's going to stay in there, that becomes an income property. Because I need a copy of what? I need the lease, I need the security deposits, I need the right?
Estoppel certificate.
Yeah.
Not fully on.
You know what the estoppel agreement is for? That is where the tenant gives you a document saying, here's what my rent really is. Because in the commercial world, the listing agents are liars. If you've ever tried to buy one and it says, you know, the rents are $9.50. That means that's what they should be, not what they are. I mean, that's the kind of stuff that happens in that industry. It's really, really scary. Okay, what about number 4?
Also, question there.
Whatever.
That means.
I'm married. I've been called a lot worse than that.
For question number 3, that means any units 2 and over should go to commercial
Always.
contract.
Yeah. Now, unless, I mean, it's kind of technical, but I can say this. Let's say the buyer is buying the duplex and they're kicking the tenants out.
So parents and them will stay together?
Yeah, maybe they're moving in, like my mom and her sister bought a duplex and lived on each side. Do they care about what the tenants are about?
Only if they inherit the tenants,
Yeah, if they keep them,
or if they're in place when the deal closes.
right, because doesn't the tenant have rights?
Still, yeah, as long as.
Because guess what this contract says about possession? It says the property be vacant and close of escrow.
Right.
Is that going to be the deal if you got tenants in there?
No.
No, because they have leases and they're entitled to stay there. So can you see, this is a lot more complicated than we make it, do you agree?
Right.
And I want it complicated in front of my buyer, because maybe he's talking about buying an income property. So I'm going to talk about those issues. And do you see that what you talk about will change based on who the buyer is? Does that make sense? Mm-hmm. Okay, what about number 4? We've got that right. It sounds logical. In fact, since I've been in the business, the contract always said repairs to be done prior to close of escrow. It always said that, right?
And now it says prior to the walkthrough.
Right. But the problem is, if the seller has up until close of escrow to do the repairs, how am I going to do a walkthrough?
Well, you can, but you have to base a lot on faith.
Yes.
No, unless
Is
you
that like
agree to it.
faith? Is that like trust me? I mean, come on. What? How does that work? Yeah, trust me, sure. Yeah, right. The problem is that you want the work done prior to the walkthrough, so that what? Why are you there? You're verifying. Part of the things you're doing is verifying the work is done. Do you agree?
Right.
Does that make sense?
Yeah.
So look at paragraph 15, by the way. Paragraph 15. See, all this isn't made up. It's actually hiding in the contract from you. Paragraph 15, first line says, repairs to be completed prior to verification and condition. So do you think our sellers should be told that? Yeah. So I'm going to change, by the way I do my business, and I'm going to call you and say, Guy, I want to do my walkthrough next Tuesday. And the agent says, okay. But do you think I better say, by the way, is work going to be done? Because if it's not, I'm not going to do my walkthrough. Does that make sense?
Yes.
Well, let's look at another couple of issues, by the way, in paragraph 15. Go down to line 1, 2, 3, 4. At the end of the line where it says seller shall. Are you all there?
Yeah.
Okay.
With paragraph number, sorry.
Paragraph 15, line 4. Seller shall at the end. Seller shall obtain receipts for repairs performed by others. Number 2, prepare a written statement indicating the repairs performed by the seller and the date such repairs were made. And number 3, provide copies of receipts to the buyer prior to the walkthrough. Now you guys are selling houses. How often does that happen? Like never? Why?
It's just unfortunately overlooked.
Because it's hiding in the contract, right? But that does not make sense that during the walkthrough, that's when I would get copies of receipts for repairs that were made by others, and I would want to get, if the seller did the work, I want to find out what you did. Does that make sense? Mm-hmm. So when I call and I always say I'm going to do it on Tuesday, is the work going to be done? By the way, according to paragraph 15, I need copies of receipts for all repairs done by others. And number 2, a list of repairs done by the seller. And the other agent's going to say, What? Isn't he? But I didn't say that's what I want. What did I say? It's what the contract says.
So just to be clear here, we're talking about repairs that are part of the contract.
Yes, that the seller's agreed to, because this is an as-is contract, so the seller must have agreed to do something, but when they do, then that paragraph kicks in, right? And you have a duty to follow the contract. But the problem is, can you see how in a lawsuit, let's say it had nothing to do with anything about repairs, and yet the lawsuit was about something that wasn't disclosed, and during the trial you were asked about paragraph 15, where it says you were supposed to have copies of receipts and the seller list, and did you provide those to my buyer? And you would say what? I don't remember. Or, I mean, do you see how you could look stupid? Because they put it in the contract because you're supposed to do it. And I can tell you, most of you probably aren't doing that. And I would suggest, Don, that maybe, I don't know how your delegation here is, but that might be something you put on your closing checklist. Because it's required by the contract. So if the agents aren't getting it, maybe they shouldn't get their check. Maybe. You know, that's a policy issue. But most offices don't have that on their checklist, and yet the contract requires it. It's just kind of crazy. Why would I want contract if I'm a buyer?
To prove that it was done.
Prove it was done. Second of all, I'm walking around and you're saying there was a leak under the house that it got fixed by a plumber. How do I know that? Trust me? Come on. And I also want to have somebody to call in case something didn't get fixed, right?
Right.
Also, let's look at line 2, line 1 on paragraph 15. The second sentence is an amazing thing to talk to a buyer about, by the way. It says, repairs to be performed at seller's expense may be performed by the seller or through others. How will the buyer feel about that?
Not going to be too happy.
Yeah, I mean, isn't that the stupidest clause you've ever heard of?
Hand in hand.
You know, are you aware, Mr. Buyer, that, by the way, the purchase contract, if we use the car form, says that the seller can do the repairs if any are found. What do you think of that? They're going to go, what? I mean, that's not even logical, right? So that means if we have roof repairs, that he's going to be up there? Think about that. Or is the chimney cracked? He can do the, I mean, how crazy is that? So what do we say to a buyer? So a buyer might say, I wouldn't want that to happen. Say, well, here's what our options are, Mr. Buyer. Here's our options. One is we can go and change the contract. And just like the PRDS contract, we can say all repairs under this contract should be done by a licensed contractor. Would that solve your problem? And they'd probably say yes. Now, here's the truth, Mr. Buyer. Based on today's market, in your price range, every house we go look at are going to be multiple offers.
Yeah.
And if there's 10 offers and I put that in the contract, you're going to be kicked out. True?
True.
Yes.
So what would you like to do?
Do it myself.
But the buyer does, I mean, can you see the buyer's going, damn, I haven't thought of that. I mean, my job in this meeting is to get them to think, this guy's telling me stuff I didn't know, maybe I do need him. See, I could probably capture a buyer only by paragraph 15. Powerful paragraph 15. The seller, I don't even know. Here's the other thing that scares me. Who is and/or others? Are they standing in front of Home Depot today?
Maybe.
Or the guy on the exit sign down here on Alameda and 880, you know?
He doesn't want to.
Yeah, he doesn't really want to, but he's got a nice sign though. God bless you on the bottom. I saw that one, yeah. Unbelievable. Anyway, but do you see how this, certain parts of the paragraph is going to hook certain people? That's what I'm about. Am I trying to teach them the contract, by the way? No, I don't care if they know the contract or not. I'm trying to get them as a client by showing them I know more than they know. That's what my job is. My job isn't driving you around and saying, hey, isn't this a cute kitchen? Yeah, I'm not going to be doing that. Guys aren't comfortable doing that anyway. Okay. Okay, what about number 5? Anybody get that right?
No. Okay, I said it was false. What was the answer?
It is false.
Yeah.
No, it's true.
Okay, yeah, so show me that one.
Okay. It's hiding in the contract.
Tell me.
Paragraph 10D. Paragraph 10D. Line 1, 2, 3. Buyer shall carry. Are you there?
Yes.
Some of you are still flipping pages.
Indemnify.
Buyer shall carry, or buyer shall require anyone acting on buyer's behalf, who goes on the property on the buyer's behalf? Inspectors, typically, right? Buyer shall carry, or buyer shall require anyone acting on buyer's behalf to carry policies of liability, workman's comp, and other applicable insurance. This has been in the contract since 2007, by the way. And yet you didn't see it, did you?
No.
The other agent hasn't called you on it either, have they?
No.
So how scary is that? Can you imagine a lawsuit, again, where your property inspector messes up and they have no E&O insurance and you're the one that sent them out there? It's called negligent referral, by the way, where you're sending out you referred the wrong kind of people and made mistakes. You're going to be absolutely liable for that mistake. But look what it says. Buyer shall carry. Now, is the real world the buyer going to carry an inspector on their policy? Is that going to happen in the real world? Of course not. Or buyers shall require anyone acting on their behalf to carry. So are you going to say, Mr. Buyer, here's the inspectors I use, would you call and verify their insurance? Is that going to happen? No. Of course not. What the real world is, if you're going to comply with this contract, you're going to have to pick up the phone and verify your inspectors have insurance. You're going to be shocked to know how few do. Now, the ones I care most about, to be honest with you, is home inspectors. Because buyers rely more on home inspections than probably everything else combined. Do you agree?
Yeah. Yes.
How many of your home inspectors have E&O insurance? Do you know? They do? How do you know? How do you know?
He said it.
Oh, he said he did. What's the problem with that? Yeah, how do you know he does? Yours does? How do you check?
I look for license contractors.
Okay, what's that have to do with insurance? Has nothing to do with insurance, okay? And do home inspectors have to be licensed contractors? No, they do not.
Most are not licensed.
Most are not licensed, which is okay as long as they're competent, right? You said yours does. Have insurance?
Yeah, but if I have a question, I'll just call.
No, but how do you know he has insurance?
Well, I'll call the state if I,
The state doesn't.
and sometimes, usually
The state has nothing to do with insurance.
but usually they will show me identification.
Who will?
The home inspector,
Okay.
those that I hire.
And he shows you his insurance.
Yeah, the policy's there now. I haven't seen the policy direct. So to
Okay.
answer your question, no, there's no way that I would know 100%.
Exactly. That's where I want to teach you. You don't know, even if you've asked them. Most of you haven't even asked, by the way. Do you agree?
Yeah.
So I'm going to suggest that you get on the phone and call your favorite 6 or 8 people and say, number one, do you have, based on the contract, do you have liability and workman's comp? And the answer is yes, you do, or no, you don't. Then if it's a home inspector, I'm going to ask in addition, do you have E&O insurance? And they're going to say yes or no. Here's what my experience is. I've been teaching this since 2007, by the way, when it came out. But most agents haven't gotten it. The ones that have done have called me and said, Guy, because I also trick them with another question, that if they say yes, I say, would you send me a copy of your policy that I can put in my binder to show my buyers and sellers the kind of person that I choose? And they say about half of the people that said yes admitted that they really didn't. How scary is that?
That's very scary.
So the point is, why couldn't they send you a copy? It's just one page, by the way, the front page. But you'll find out if they don't have it. And what I would do is say, look, I've been using you for 20 years. I love you. I want to continue to work with you. You better get it now because it's in the contract.
Right.
Why do you think a person wouldn't have insurance if they were a home inspector? They can't afford it, which means, when they miss the foundation, are they going to have enough money or be in business at all? The answer is no. Or, number one, they can't get it because they've had so many claims that the prices are so high they can't really afford to buy it. You know, either financially can't buy it or can't really, you know. So both cases are bad, by the way. I did call a home inspector, by the way, on a case that we have coming up that's probably going to be filed this year against a home inspector who messed up really big time. But I called him and said, hey, I'm in the business and I understand you do home inspections. And said, yeah. And I said, by the way, I just went to a contract class and it said you have to have insurance. Do you have insurance? He says, no, I gave up that E&O policy. I got tired of being sued. What? And he's probably one of the most commonly used home inspectors in Santa Cruz Mountains. Do you think the agents know that? No. I'm not going to tell you because maybe he has insurance and I'd be sued. But that's scary, guys. I'm telling you, it's what it says. Now, do you think we ought to talk to our buyers about paragraph 10D? Absolutely. What a great discussion as a risk manager. By the way, Mr. Buyer, have any other agents told you that the clients that you're required to carry insurance for any of your inspectors that come out to the property? What? No other agents told you this? Could I make a good discussion with a buyer about that alone?
Yeah.
Well, yeah. And I've verified all my inspectors that I'm going to use when and if we have to do inspections have got insurance. And by the way, here's the copies.
So Guy, from what you're saying, that when I asked the inspector or general contractor in the quote, they sent me saying that, at the bottom saying that I carry or the company carries E&O, blah, 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 workers' comp, would that be valid?
No.
No, because
that's a good marketing technique.
Well, how can one actually verify it?
They send you a copy of their policy.
policy, yeah.
Well, that's what I said earlier, that I had a copy of the policy, but...
Well, I didn't hear that.
But I don't-
Did you guys hear that and I missed it?
No, well, maybe I didn't say exactly that,
Oh.
but what I meant is, there's still no way of knowing unless you can verify that the premiums have been paid.
Well, that's true, but at least we're doing what I would call reasonable. So if during a case, somebody said, Mr. Berry, would that be reasonable on the part of an agent to have verified by the copy that, I think the agent did as good as you can do, right? Yeah. It's not our job. But if you have an assistant or whatever, some of you do, you might want to make sure you keep that up to date because policies change, they expire, they renew, annually. And yes, I had one yesterday, but I don't have it anymore because I quit paying, like she said. But the point is, when I'm talking about, I'm not just talking about how to practice real estate, I'm talking about what I'm going to say to my buyer, about what's important and what the risks are. Can you guys kind of see a little bit, maybe, that if you knew as much about what the contract said, that you'd be a better agent?
Yes.
Or at least, even if you're not a better agent, do you see how many you might be able to capture more buyers and control them and keep them? That's where I'm coming from.
More knowledgeable.
Yeah, because and don't I want only to deal with people that are knowledgeable? You see, I want that 10% group, don't I, when I'm a client? But see, have you ever had a client ask you the right questions? Do they even know what the questions are? They have that, right, they have that, because they think maybe the size of the company matters.
Or they haven't tried.
Or how many houses you've sold. Or how long you've been in the business. Or all the things that they kind of superficially matter. But that's not really what matters. Like, they don't know how to ask the right questions. The point is, they just don't know they don't know, but they think they do. Too many of them are engineers. Do you agree? Anybody in here an engineer? Not going to admit it? Somebody must be. Anybody married to an engineer? They're a different class of people, right? But they're very technically oriented. They love data, they love protection, they love all these kind of things we're talking about because they're math-based. And math-based people don't believe anything because they test it and test it and do it over and over and over and over and over and test it and test it and test it. That's why we have engineers build bridges, not realtors, because they test stuff and they want to have data. And so if you have more data, because they think you're just a salesman, they don't want to be around you any more than you want to be around those idiots at a car lot, right? Here they come, oh my God, So you know what? If those guys knew anything, I might want to talk to them at a car lot.
Wheels and deals.
Yeah, you think? You know, how does your car compare to the, you know, they have no idea. So they're not even worth talking to. Do you see how valuable that paragraph is?
Yeah, it is.
See, there's hundreds of that. By the way, how long are we supposed to go today?
We have an hour left.
1 hour? Okay.
4 hours.
Okay, what I'd like to do is maybe do one or two more, and then we'll take a short break. That'll be good, Don? Okay? Okay. This has been worthwhile today?
Oh,
Yeah.
absolutely. Good job.
Wonderful, thank you.
So who do you think you're going to tell that wasn't here today what an idiot they were?
Oh, only when we need to.
The price, based on what you paid today, that's what you're going to get, by the way. I'm going to give you everything you paid for. Okay. What about number 6? Why is that false?
Seller.
Because they have to send the notice to perform before they can cancel.
Right. There's several reasons why this is false. And here's the premise. The buyer said they're going to remove contingencies in 10 days. 10 days comes and goes. The buyer doesn't perform. So the seller says, let's kick them out.
Send them notes.
You can't, because first of all, the contract says you have to send a notice to perform. Which is ridiculous, by the way, if you think about it. Why is that ridiculous?
Because it's a contract?
Yeah, there's you nailed it. This is a contract. You promised you're going to perform. In fact, we negotiated the contingency timeframes because you came in on the default at 17 days, and I counted you down to 10. So why is it okay on the 10th day that you not only have not performed and not be in breach of contract, but I now, as the seller, have to send you a notice
I remind you to do your job.
and give you an extension. Did you know that? The notice also gives you an extension. So
I
it's,
told my buyers
what?
that if we don't remove our contingencies in the period, the seller has to give us a notice to perform, and we buy it however many days we put it in the contract.
Absolutely.
Yeah.
My job at my office, by the way, is risk manager, and so he just come to me and say, Guy, we're on the 10th day. We haven't got our loan approval yet. What should we do? And I say, what? Do nothing. In fact, don't answer your phone. Don't look at your email. Because why? The seller can't do anything. The only person in California that can kick a buyer out of a contract is a judge. Did you know that? Because I can call escrow and send a cancellation, and the buyer ignores it. What's going to happen next? Is the property canceled? No. Can I sell it to anybody else? No. Why not? I need a release.
Release?
Do I have a release?
No, or cancellation.
Do I have a cancellation? No. So the buyers got me, don't they?
Yeah.
That's why the contract is ridiculous. We're in California. Every state doesn't do this. California is all about kumbaya, and let's all hug and be happy and love each other and give them more time because the buyer just is trying all they can. And so that's the truth we've got to tell our seller. You can't do anything. You can send a notice. Now you can, by the way, under law and under a contract, send a notice 2 days prior to the contingency.
Yes. Not more.
So you have to send it again. By the way, do you think that's going to make the buyer perform? Do you think the notice makes them perform? I don't think so. My experience is most buyers don't even know they're not performing, by the way. Because they don't, you think the buyer's agent explained the contract to them.
No.
They don't really even know what the deal is. Here's the real deal. Here's what I want you to do. You're sitting there with your seller. The buyer hasn't performed. You've sent your notice. They're not responding to that either. I want you to get up out of your chair, and I want you to run to the front door and open it and look outside and say, no buyers out there, let's stay with this one. What do you think of that?
Are there any penalties to the buyer for not performing on time, even though there's a lien on the contract?
She asked a really great question. I'm going to teach you a concept here. Ready? What does the contract say?
I don't know. I haven't got that far.
She made a great point. What does an REO contract say?
$200 a day or whatever.
Yeah.
Spell it out.
So why aren't you as smart as an REO seller? You ever thought about that? In this market, could I get away with it on a multiple offer of 10 offers and put a counter that says buyer will pay $100 per day if they don't perform on time? Could I get away with that? I'd get away with anything today. So why aren't you doing that? So next time, by the way, Don, somebody comes in and whines about a buyer not closing on time, tell them that.
But is that in the contract penalty option?
You write it in the contract.
What does the contract say? You have to write it in. You have to counter it.
So you have to write it in.
Yeah, it's not in the contract.
My builder wants that.
Sure they would. I mean, why shouldn't you? It's not fair for a buyer to come in and lie. That's called lying, by the way. I'm going to close in 30 days. What if you don't? Well, I'm sorry. And your seller's going through hoops. I just had a seller had that happen, by the way. I don't do it. I probably should be doing it, but even I don't do that. And what happened is it slipped from closing on Friday to Monday.
Okay. 3 days,
Right.
$600. What are their holding costs?
Well, it wasn't only that. The biggest problem was the moving company,
Penalties and it costs more money on the weekend.
not only not more money, he didn't have any more trucks. He wasn't even available on that following Monday. We had to change companies to get somebody to respond. And how quickly can they respond with 2 or 3 day notice? So we had to take the best we could, and it cost him $2,000 more than it would have been had they been able to move on Friday. Because I didn't put anything in the contract, we couldn't get the buyer responsible for that. You see the problem? It's our own fault, half of this. Right? You should be countering with that on a multiple offer so that your your seller's protected. Now,
So you're actually saying that even with the notice to perform and they don't perform, you can't cancel that?
all you can't cancel.
Sell it.
The seller can't cancel either. What you have to do is go to a lawyer, and what they're going to do, by the way, it's kind of interesting because I know a lot of lawyers, as you can assume. They send another notice to perform, by the way. They say, look, you have a contract, here's what you promised. You didn't do it. We sent you a notice, you ignored that. We now are going to send you another notice, give you X number of days, or we're going to kick you out. So then they ignore the lawyer letter. What happens then? Nothing. And the lawyer comes back and said, look, the buyer is absolutely in breach of contract. It's clear to everybody. Do you want to file a lawsuit? Because that's what it's going to take. If you give me a check for $5,000, we can start the game. That's the real world, guys. Is that good news?
No.
I think it's terrible news. You think we ought to tell our sellers this?
Oh, yeah.
Yeah. Otherwise, they're going to be screaming at you about they think you've done something wrong. The point is, do they want to pay for a lawyer? No.
So how does the seller get out then if the buyer?
You have to go to a lawyer and file a lawsuit to kick the buyer out. And whatever the retainer is. And it's, at least $2,500, maybe $5,000, because they'll sneak up on you, but we'll get $2,500 up front, but then, at $400 an hour, how long does it take to spend that money? Yeah.
Does the demand to close escrow one of the agents to help close out?
We can send demand to close escrow. There is a form like that, right? I mean, there's a notice to perform against the buyer, and there's a notice to perform against the seller. The problem is, so what?
So Guy, I guess that's one of the reasons that I've heard of a few transactions, the buyer delayed the closing and came back to renegotiate with the seller
Right.
of the price because they already added 15% to get in contract in the first place.
Right.
Wow. So because the seller cannot kick out the buyer for in the contract. So they use that as a leverage.
Sure.
That was a ploy,
It's a ploy.
a dirty meditated ploy.
It is terrible. I mean, they have the right to either sue that buyer or kill them. One of the two. Right? Because that's a game.
That's a game.
Yeah. In fact, I have agents that have told me they don't put a lot of stuff in the contract because they'd rather come back later after we've run off all the other buyers to give them more leverage. I just think, how rotten is that? But
When you get that contract, then you better watch, you better read.
Yeah. So yeah, I didn't want to be the bearer of bad tidings, but the point is that's the reality of what this contract says, and it's a ridiculous thing. I mean, a notice to default is the dumbest thing. I mean, if you don't perform, you should be in breach of contract. clearly. But you still can't kick anybody out until you take them to court and a judge says you're wrong. Because here's the basis of that, by the way. Let's say they're supposed to, a 45-day close of escrow, and they're supposed to remove contingencies in 10 days. And we say the buyer's in breach, it's the 11th day. Does that mean he's not going to close escrow on time?
No.
No. Do you see the point? That's the way a judge is going to look at it. The buyer hasn't breached the contract until he doesn't close. Right?
30 days later, yeah.
And if he closes on time or even a day or two late, how was the seller damaged? That's going to be the argument. Sellers don't want to hear that. Question?
So Guy, what happens if you counter with a per diem?
Okay.
And they agree,
Okay.
and they don't close on time, they close 10 days late.
Okay.
Now they don't want to pay the per diem.
Well, they can't. Escrow is going to put it in there.
Yeah, the escrow's going to put a hold on the funds, right? So it can
Yeah.
still.
Escrow's going to put them on the closing statement.
Closing statement.
With a negative to the buyer and a,
And a positive to the seller. Yeah.
But what if they don't agree to it, is what I'm saying?
well, then they're not going to close.
All right, so here's the thing.
Well, then they put their deposit at risk.
Exactly, so now you won't close, it's held up, you gotta wait for a judge to decide, hey, is that what happens? Because I've seen a lot of times the buyer will eventually perform if they close late. So they perform, whether they agree to per diem or not. So now they get to the end, they're like, I don't want to.
If they are
Paying attention, and they've got a halfway smart agent, they say, look, you can't not close over this because you agreed to it, it's in the contract.
Right.
Right? See, the other argument is, even a buyer that doesn't know what's inside a contract because his agent didn't tell him, do you think they see a counteroffer? See, that one they do see. What does this mean? What does this mean? So I haven't had that experience, by the way, that if it's in the contract, the buyers probably, will they like it? No. But, and here's what I tell them. If you're late because your lender's late, make them pay the $400.
So my
Does that make sense?
Yeah, I brought it up because a lot of the REOs, like you said, the banks always do it, and I've sold a lot of REOs.
Yeah.
And a lot of times, buyers will close late, and the banks have waived it, and the buyers
I know.
wanted to challenge it. I'm just
Yeah.
kind of curious.
And only about half the banks really impose it, even though they have a right to.
Right.
But the point is, legally, like you say, escrow is going to put it in their closing papers, and they're going to hate it. Well, then they call and say, we don't want to pay that. We'll say, fine, then have your agent pay it, or your lender pay it. Don't talk to us. It's not our problem. My seller promised to be on time, because he may have additional costs when you close late. Does that make sense?
And that's the reason why.
That's why. That's what this is about. It's about, you're going to inconvenience the seller who had all kinds of plans, and now you close 4 days late. You know, who knows what's going to happen.
When I had that conversation with my seller, and I said, look, I think, because of your situation, we need to put a per diem penalty in if the buyer doesn't close on time. He was a little uncomfortable, and he said, well, what if it's only 2 days? And I told him, then you can waive it. But what if it's 30?
Yeah.
And he said, okay. Well, yeah, let's do that. We got no pushback from the buyer's agent.
Yeah.
None.
See, at the beginning, everybody wants it so bad they'll agree to anything.
Yes.
Do you agree? There's 10 other buyers, they'll agree to any. I mean, look what the prices they're paying. Stupid prices they're paying for these houses.
Yeah.
They'll agree to anything up front. And then later at the close, they might say, what the heck did I do?
Because I do find that true where they get to the end and they say, fine, we won't close, I'm not paying it. Can the seller agree to close and then sue them in small claims?
Absolutely, absolutely. So what I advise our clients to do in that case is you perform, you go down to escrow, you sign off, and then let the buyer not perform. And then if you incur damages, then come back at small claims court and ask for them. And they'll win every time, by the way. Every time. You win every time.
So,
I need to answer that question.
Yeah, he asks questions he already knows the answer to. Yeah.
I'm reading section 14C, seller right to cancel.
Yeah.
And it seems as if it is okay for the seller to cancel if
It's okay for the buyer to start the cancellation process, but they can't decide who's in contract and not. That's the problem. They can. How do you start the process? You have title, escrow, send a notice of cancellation. But then that doesn't cancel the contract. Legally it might, but who's going to legally enforce this contract? The buyer? The seller? The attorney? No, a judge.
Judge.
It's got to be a judge. Do you see this is a little more complicated than we think, let alone what a buyer thinks? The buyers have no idea what the heck this is about. So, question?
Does the same thing work for returning a buyer's deposit? I mean, I can hold that up, it takes 2 signatures?
Well, no, because there's a law in California, I forget what it is, Civil Code 1053 or something. It says if you unreasonably withhold a buyer's deposit, you can be fined $1,000 plus attorney fees.
Isn't the buyer being unreasonable by...
Absolutely. And how are you going to enforce that?
Got a gun?
That's the old way. You know, the Old West had things figured out a little bit better than we do. Do you agree?
Yes. Wow.
I know.
Guys, the solution is basically if there's a snake buyer agent, work with the buyer, delay the closing, so
Right.
the seller just, and the listing agent just patiently wait until it gets closed and come back to sue them for the damage that has evidently...
But you have to perform. That's why the seller has to go down and do what he promised to do within the time frame, and then when the buyer doesn't,
Yes.
then he'd have to prove damages.
Yes.
The point is, I love this counter though, where we input it. If the buyer knows, forget what their agent thinks. If the buyer knows they're going to pay $100 a day, they're going to pay attention. Otherwise, they don't care. What's the point? Because it's just like I said, we do nothing. Pardon me?
Is there an unreasonable figure for the law?
Unreasonable figure for what?
Per day?
Yeah, I think there is. Reasonable is what always is the test. What seems reasonable? If the seller's cost is $10 a day, probably $500 a day wouldn't make sense. But if it was $100 or $200 a day, is that a problem? I don't think that would be. Would you, if you were on a jury, would you think that was unreasonable? No. What if it was $1,000 a day?
I don't know, what's the value of the property?
Yeah. What's the seller's damages is going to be the
What
test.
are their holding costs?
Yeah. $1,000 a day might be a little much. Do you agree? Because look, does the seller care about the $100?
No.
No, he really cares about trying to get the thing closed.
Yeah.
So it's more of an incentive to get the buyer to close than it is to. That's what banks have figured out. That's why REOs do that. Yeah.
That seller would care if he's doing an exchange.
Yeah. Or if the property's going into foreclosure, or if it's vacant and I'm paying double payments. I mean, there are times when it probably is. Is this stuff we should know?
Yeah.
Yeah.
Very important.
That's why I love to tell the stories too, because people love stories more than facts, because they can relate to them. Okay, let's do one more and we'll take a quick break. Okay.
Number 6 again, we as buyer's agents, we basically tell our client, because our job is to protect our buyer
Right.
at any cost. So
Exactly. Absolutely.
we say that, hey, look, we don't have to cancel, we don't have to do anything,
That's right.
and they cannot do anything with
Well,
about us.
they can try, but is the real world? How many sellers are going to really go to an attorney and try to kick a buyer out? I don't think that's happened twice in my career, probably. It doesn't happen. So if it's a day or two, just say, look, we're doing the best we can.
What does that say in terms of our reputation within our peers as realtors? If we're acting this way, yes, we're acting on behalf of our agents, but then
Absolutely.
what does it say
Well,
about
I think it depends on how you handle it. So if your buyer has no intention to close, cut the deal loose.
Exactly. Don't play with us.
People
Yeah.
who are sitting on it for malicious purposes. I think the majority of the time, there's no malice there,
No.
you know, and properly handled, you know, there don't need to be notices to perform. Some clients will only wake up and pay attention when they get something that looks quasi-legal.
Yeah.
Okay, and that's when that's used, but I think.
That's why notice to perform it was developed, by the way, to get the buyer's attention, because the agent may not have told them anything, but the form goes to the buyer. They go, what does this mean? And they have to tell them. But I think you got a good question. I'm not sure.
Like sometimes it's uneducated, brand new agents, engineers, they put on there that the house is for sale again.
Well, they could say that. Like, have you ever seen on MLS subject release?
Yeah.
because you can't resell the property till, but how many people are going to show that property? Are you going to show a property that says it's subject to release of a prior buyer? I'm not going to even waste my time with that, right? So it's a big waste of time. Now, buyers can't have to act in good faith. That's the real answer. Is your buyer trying? Now, let me tell you what my experience is after a million years of doing this. Most people are late because of the loan. Do you agree?
Yes.
Is anybody here in the loan biz or was? The number one reason that loans are late is the buyer's fault for not turning the documents in.
Right.
Do you agree?
Yes.
Appraisal, right now, appraisal.
Yeah, but look, if you have 20-something days, you know why you don't have the appraisal yet? Because you didn't pay for it. You waited till the very last minute to put up the $400. So I mean, the point is, quit playing with me here. Because look, I just had an escrow close in 16 days with a loan. If you do your paperwork and all turn them in and get it all done up front and the verifications and all that up front, they can do a loan really quick, by the way. So don't tell me the buyer's not performing. He didn't turn in this and his mom didn't do this and the gift letter and all that stuff. So maybe you ought to fire your lender because they didn't say, here's what I need now. And the point is, why isn't that done up front? Part of it is us. Do you agree?
Yeah.
Because they're not really pre-approved. They're pre-qualified because your pre-approval is this stupid phone call, and then they write this letter that says the buyer appears to be, have you fill out a loan app? How many pre-approvals do you think have the buyer fill a loan app out?
None.
Like none? How many have had their credit run already? Like none? So look, this is why knowing this contract is so powerful, guys. Turn to paragraph. You can see I could spend hours on this. What paragraph is it that talks about the loan, the pre-qual letter? No, it's paragraph H1. 3H1. And paragraph 2, page 2. Look what this says, guys, and this is something that's been in the contract forever, and you're not doing this. You are not doing it. It's not the buyer. It says, within 7 or blank days, the buyer shall deliver the seller a letter from a lender, and we all get letters, right? But look what it says, stating that based on a review of the application and credit. So how many letters are you getting that say this buyer has filled out a loan application, we run their credit, and is pre-approved or pre-qualified for a new loan as described on 3C, meaning that not only that, but they also looked here and the buyer's qualified for this loan. Not a loan, this loan. They don't say that, the letters don't say that, do they? Some. So you know what? You get a buyer's pre-approval letter, you decided to accept that offer, you counter. Buyer to provide within 24 hours a new pre-approval letter stating the following. That's what I do. Because that letter means nothing. Because all they made is a phone call. So that's our fault. Do you see that? Have any of you had problems with the buyer having loan problems after he was pre-approved? I mean, how can you have loan problems if you get a letter from the lender saying you're pre-approved? That doesn't even make sense, does it? How can you have loan problems? The lender says he is qualified. All of a sudden he has a credit problem? How can he have a credit problem? 30 days ago he had a pre-approval letter saying he didn't have a problem.
You bought a car? Yeah.
Yeah. Yeah, we all had clients do that.
Oh, yeah.
But at least do it right up front. But see, you haven't earned the right to demand that by saying, I want you to use my lender, and here's what I want you to do. Well, my mom has a friend who lives across the street, blah, 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 some stupid comment like that. The point is, I'm going to get enough respect so they start listening to me, because it matters. So am I going to talk about 3H2 or 3H1 to my buyer? What do you think? Yeah. And why it matters. To find out the wife is on commission. Yeah, she made $52,000 last year, but $32,000 of it was commission. but the previous year she only made 20 commissions. So the lender's going to say, has your, you know, all those issues that we don't even think about. Okay, why don't we do this? It's about 2. Can we do it in 10 minutes?
Yeah.
10 minutes, come back at 10 after? We'll finish by 3? Is it 3? 2:30. Okay, 2:30. We'll finish.
We're rolling.
And by the way, I use Blake for my videos as well, so he is a great guy. Very reasonable and gets stuff done perfectly. So anyway, what I passed out to you, by the way, was what most agents have said to me, Guy, I wish you could sit down with me and coach me through the contract line by line and what it says and how to say it. And unfortunately, you can't afford me. I mean, that's kind of mean to say, because I charge $300 an hour to attorneys on my expert witness work. So I mean, if I sat down with you, you probably couldn't afford for me to teach you the contract. But what I did is I put it on CD, because this kind of an oblique story, but I want to tell you how this happened. I've been teaching these contract classes forever. We were talking, Meredith and I were talking about, I taught classes at the Saratoga board when there was still a Saratoga real estate board 20 plus years ago. And the problem is, agents said to me, Guy, I loved your class, but I forgot what you told me by the time it came up. Right?
Yeah.
Like, I forgot what I had for lunch yesterday, let alone what Guy Berry said 6 months ago. So it always bothered me. And about 20 years ago, maybe not 20 years ago, 15 years ago maybe, I was driving down the freeway and a Beatles song came on. You know what year the Beatles came out with that song? 63. I knew every word. How's that possible? It was 20-something years later, and I knew every word because I'd heard it over and over and over and over. So that's what I did. That's why I said that's the answer. So I've gone into the recording studio and took the car contract, not to teach you the car contract, because contracts change, right?
Right.
But to teach you generic contract law about here's what a deposit paragraph means, here's what a repair paragraph means, here's what a contingency removal paragraph means, and that's what this is. 6.5 hours of Guy Berry making you boring.
Is this updated since the first one? Is this the first one you put out?
No, this is about the, I came out first on cassette. That's how many years ago it was.
No, I have a group of CDs.
Well, it could be 2007 or 2010, I don't know.
Okay.
But so that's what this is a reason for you to listen to it over and over and over and over again. By the way, it's available on CD and MP3. The young people in the room don't know what a CD is, right? Some people get both. They put CDs in their car and then they use MP3 if they're bikers or joggers or hikers. Or one lady told me she puts her headset on and cleans her house every Saturday morning and listen to my CDs. So you do whatever turns you on. But there's a couple of bonuses, by the way. One is there's a CD here called The 10 Biggest Deal Killers. We still have an incredible amount of deals falling apart. And I've gone and studied and said, here's the 10 reasons they fail and how to prevent them. I can tell you, if you listen to this one time in your career, you'll save a deal. I really mean that. There's no reason. Most deals are savable. The only valid reason for a deal not closing is a buyer died. I don't have control over that one. The second bonus is condos, clients, and catastrophes. This is telling you about condos and HOA documents and reserve studies and litigation and all the issues. As I said, this will either make you an expert, like if you're farming a condo complex, or you won't want to ever do one of these again because it's that complicated. It's like double the work if you do it right over a single family home. And then here's one on income property. You may think you know how to do an income property. I can tell you, sitting here, you don't. Duplex, fourplex, and other disasters, this is called, by the way. This is a great deal. And I talked to Don before the meeting.
Before he says that, by the way, if you haven't listened to, I've listened to every one of those a number of times, and if you haven't listened to just the bonus ones, you're missing. The car contracts are good, but the bonus ones, I learned things, I've been doing it 32 years that I had never known about.
How many people have my CDs? Some of you already have my CDs. What's your opinion? I mean, I can stand up here and tell you they're great, but
No, it was awesome. I listened to it all over and over and over and over.
okay.
Someone actually gave me the original copy, and then I
Bought your own?
went to your class, yeah.
Well, that's so nice. I love it when somebody buys them. They're good. Anyway, what I'm saying is, I can say how great they are, but people that you know say they're really great.
They're very understandable, it's not complicated.
Well, you've heard me teach today. I do not talk in complicated. I don't talk in legalese, because what I try to do is say, here's how to explain it to the client, because it's not you understanding, it's your ability to communicate it. Like, for example, you don't know how to explain what a contingency is. It's a condition, or it's a subject to, or it's a condition proceeding, or some other stupid comment you might make. You know what a contingency is? A contingency is the buyer's right to walk away. They'll get that if I say it that way. Huh?
Their get out of jail free card.
It's get out of jail card. But I mean, that's the way they understand it. So anyway, that's what this is. And if you want them, I do have them. But what I was going to say, I made a deal with Don, is we're going to discount them for you. And also, somebody who buys them today will get them free, because he's going to buy one for somebody.
I'll buy one.
Okay? So if you have a business card, you don't have to fill this side out at all. Just tell me how you're going to pay. Credit card, check, or cash. And if anybody in the room forgot your way to do it, like you don't have your credit card with you, just write "call me." My wife will call you and get the credit card number over the telephone. So, by the way, the MP3 or CDs, instead of $99, are $69.
Wow, that's incredible.
You paid $99 for just the CDs. You didn't even get the bonuses.
That was, I think, 3 years ago when you did Class
Could be.
Public.
Yeah. Yeah, you paid $99. Yeah, yeah, $69, and you can have either CD or MP3, or if you do it smart, which is what I suggest you do, get both the MP3s and the CDs, and that instead of $125, it'd be $99. Can't do better than that.
And is this for the 2010 car contract or the 2013 car contract?
The 2013 and 10 are the same, except for one paragraph, which we're going to talk about in question 12. And it's about 11 or 12 hours for $100. Come on, guys, it's the bargain of the year. And here's the other bonus. How many people would like to call Guy Berry and ask him questions when you're stuck? Is that worth anything?
Yes.
If you buy my CDs, you can call me anytime.
Okay.
Huh?
I need a form.
Oh, you didn't get a form? Anyway, I think, you got to invest in yourself. Remember what paragraph 15 was about? Or sentence, question 15? Was what?
15?
I think it's time for me to make a commitment to be an expert.
On the contract, yeah.
It's up to you. I can't decide what your goals are. And I can tell you, $69 is not going to change my life. Especially if you're a brand new agent. This is such a master's level course for the contract. Secondly, if you are agents that deal with your clients or people with a second language that's not English, huh? If you're dealing with clients in another language, you almost essential to have this, because you need to know the contract better than I do, because you're trying to translate it in your head. I don't know how you even do that. I can't speak English very well.
Are these going to be mailed, or do we pick them up, or do you have
I have them today.
have
Have them today. So, yeah, I always say that English is my second language because I was raised in the South, and so I don't speak English as well as I probably ought to. Guys wouldn't believe it. I actually came from Alabama.
Oh, wow.
You and Sharon.
With a banjo on my knee.
Good to be here.
Yeah, Sharon Butler.
Yep.
That's where she moved back to.
I know.
Yeah, okay, what number are we on? Let's get through this thing.
Okay.
Okay, we're on 7. Turn to paragraph 26A. This says mediation arbitration has to be initial for it to apply. I say that's false. Why would I say that? 26A.
Page 7.
26A.
Dispute resolution. Yeah.
There is no initials on 26A. Do you notice that?
Right. For mediation.
It's only for arbitration. Mediation is mandatory in the contract. And by the way, if you don't know this, agents are always somehow putting mediation and arbitration together. They have nothing to do with each other. Nothing. Mediation is the concept of having the parties sit down together and try to work it out with a neutral third party. It's like, for example, if you have a roof leak after close of escrow, do I need an attorney or a roofer? I don't need them yet if you can figure it out between the parties. That's what mediation's about. Then if you can't settle it, then you have the right to do one of two things. You file a lawsuit. See, mediation, arbitration is also a lawsuit, by the way. People don't know that. They think it's something else. And you either fight it out in court or you fight it out in arbitration. The Constitution gives us the right to have a jury of our peers. That's what a jury's about, a jury trial. Arbitration, you give up that right and have it in front of a judge, a single judge, instead of 12 people of the public. I can make arguments on both sides. Why? Depending on who I am, where I want to be. Now, based on what the public thinks of realtors, do you want to be in front of a jury?
No.
Never. That's why our industry promotes arbitration. But the clients are different, by the way. Because if I'm a buyer, I probably want to be in front of a jury. I was on a case where the buyer was crying, her face looked like a raccoon, her mascara was running, about all the grief she had. Do you think an old judge would have cared about that? What's a judge going to care about? The contract, the law. The jury's going to have emotions. So if I'm a buyer, I probably want to be in a jury. If I'm a seller, I probably want to be in front of a judge. It's that simple. Okay, what about paragraph 8? Is the car contract an as-is contract?
Yes.
What does as-is mean?
As a condition.
Huh?
As is represented.
Okay. I haven't heard the answer yet. Mr. Roger, how you doing, buddy? Another old-time friend. Shouldn't have mentioned the old time, probably. Absolutely. It doesn't have anything to do with condition. It has to do with the seller saying, I'm not fixing anything. The contract, under other paragraphs in the contract, talk about condition. The other ones talk about buyer's right to inspect, but the issue of as is means the seller's not fixing anything. Okay? That's different than what you think. So, do they have to fix, if it's an as-is contract, do they have to fix safety violations? No. As-is means I'm not fixing anything. That's what it means. What about number 9? Why is number 9 false? I said so, REOs don't have to provide a TDS or a probate or a trust.
But they're still required to disclose what they know under California law.
Right.
Can't waive that requirement.
And in fact, they have to disclose 12 different things. Like NHD happens to be a federal law, right? So CAR's made a form. It's called REO advisory. Have you seen that form?
Yes.
There's a probate advisory and a trust advisory. They're the same form, except with a different title. So I would suggest, since the REO agents don't always know what's required, or banks back in Utah or wherever they are aren't going to care, is I'm going to provide probably that REO advisory with my offer and attach it to my offer. At least I'm telling them what I need. But what's the chance I'm going to get those documents back?
Very small.
Like almost slim, right? So let me ask you this. So back on my chair. Back on my meeting with my buyer, do you think maybe I should discuss REOs?
Yes, definitely.
We're probably not going to get all the disclosures because they don't care. And how am I going to protect myself, Mr. Buyer, from issues since the seller isn't around? How am I going to protect my buyer as a risk manager on an REO sale?
Get inspections.
Inspections. Should I inspect more? Probably. Do you think the average agent does that?
No.
No. So do you see where I'm going? All these things keep tying into the same issue. I'm going to protect you because you need to get better advice. Do they have to listen to you, by the way? Do they have to listen to you, the buyer? No.
They don't.
I don't have to listen to my doctor either, do I? But I wanted him to give me the advice, didn't let me choose. My doctor's a risk manager. Did you ever think of that? I think it's analogous in many ways. Okay, number 10. If the buyer defaults, liquidated damages states the seller's entitled to 3%. Most of you said that was false. That's not what it says at all. What it says is, if the buyer defaults, what is a default?
Fails to close after removing contingencies.
Yeah, a default's pretty brutal. That happens rare. That's the buyer that does the famous call. Have you had this call? My buyer's changed his mind. That one? That's a default, by the way. And then they don't put the deposit in at all. Because they sold it on Friday, over the weekend they talked to mom and dad who told them no, and so they call you on Monday and try to cancel a contract. There is no 3-day right of cancellation in this contract, by the way. That's a default. Or a default is after you remove contingencies, you still don't close, or you come back and try to renegotiate the contract. That's a default, where the buyer basically breaches the contract. The seller will be entitled to retain, it says, the deposit, assuming the deposit's put in the contract and put in escrow. So the only thing a seller can ever go after is what has actually been put into escrow. Okay, that's the second fact. And the third fact is the seller has to be damaged. People forget that. You don't automatically get a penalty because the buyer's a jerk, by the way. And sometimes they are. They just walk away on a deal. Okay? So is liquidated damages good for my seller? No, it's terrible. Why would you limit the amount of damages my seller can get to some predetermined amount like the deposit if the buyer's a jerk? What if the seller's a jerk? Is the buyer limited to how much they can sue the seller for? No. I mean, it's a terrible paragraph. I wish it didn't exist, but it does.
Doug Moore put that in the 70s, I think.
Could be. Yeah.
For some reason it's stuck.
Yeah, I mean, to say I'm going to pre-agree that if the buyer breaches, we're going to decide in advance what the seller's damages are, doesn't even make sense. I mean, you wouldn't, but it's in there. We're stuck with it. So understand, the seller has to be proved damages. So what happens is the buyer can tie the property up, and then the seller says, I'm going to retain your deposit, and the buyer says, no, you're not. And then the seller, they go to a lawsuit, and the judge is going to say, buyer says, I want my money back, and then he's going to turn to the seller and say, how were you damaged? And if the seller sold the property for the same or more, he's not going to be damaged. But if he did have damages, like we just had a case in Palo Alto on a big sale where the first buyer falls apart, okay, cancels the contract because he really couldn't qualify, came in non-contingent, like is happening up there. Then he realized he really couldn't get the loan and said, I want to get out. So the seller panics, takes the backup offer without ever putting it back on the market, which I think he should have done, by the way. But he took the backup offer for $50,000 less. Now he's saying, I want the buyer's deposit for $50,000. Who's going to win that?
50-50.
Yeah. Because the seller has a duty to protect their own interest. They probably should have put it back on the market, but it didn't matter. It's already, and they were already talking to lawyers because the lawyer called me on it. But I mean, can you see how that can happen? So can that seller prove damages, by the way? Yeah, he absolutely can prove. So one of the things you might want to consider if you're a listing agent and you have a buyer breach where it's clear the buyer just is a jerk, you maybe should not return their deposit until you resell the property. Because have you ever thought about what would happen tomorrow if we have an earthquake?
That happened in '89.
Yeah. If you happen to be in Los Gatos business, which you were, in '89, everything stopped, right?
Yep.
It stopped. And also we had Black Monday that same year where the stock market dropped 25% in one day. We had deals fall apart over the world. So anything can happen. So is it possible your seller tomorrow can't resell the property anymore? It's possible. Now, but how are you going to do that? How can I sell a property to the buyer who I'm trying to keep his deposit, and he knows until he releases me I'm tied up? Do you agree? So how do I do it? Here's how. You call me and you say, my buyer's changed his mind. I know he's being a jerk. He realizes that. You know, what's your seller going to do about the deposit? And all I can say to you is, look, why don't you send me a release and I'll talk to my seller, right? Let's get this started. I want to put it back in the market. So can you send me a release? She sends me a release, and you know what I say?
Thank you.
Ha ha, gotcha. You cannot file a lis penance. You know what a lis penance is?
Yes.
That's where you tie the property up. That's what it's called in the legal world. Lis penance means I'm tying this property up so you can't sell it to anybody else. You have to be trying to buy it to put a lis penance on a property. You tie it up so that somebody else doesn't buy it. You can't just tie it up over something like a deposit. So she cannot, after she sends me a release, tie the property up with a lis penance. But what I can do now is I can go over here and open up another escrow with Fidelity, because I can't find another buyer with that title company. Why?
As deposits.
Because that deposit owns that buyer and they're the client of that title company. So I open another title here. I put it back on Class 1 and I sell it. In the meantime, that money is tied up forever till we fight it out. Does that make sense?
Yeah.
Am I being the risk manager for my seller?
Yes.
Do you think most agents do that?
Yes, I've done it.
No, but I said most agents. Most listing agents say what? Oh, we don't want to tie the property up. Let's just let it go. Just let's get back on, right? That's not fair to your seller. Now, what if I'm on the buyer's side of this? What if my buyer is the big jerk? Do we sometimes have clients make stupid decisions? Yeah. What would I do? I'd do just the opposite. I'd call her and say, you're going to hate this. My buyers changed their mind. They're not going to buy. I've talked to them. There's just no hope. Now, you want to get the property back on the market, right? So why don't you send me a release? Make sense?
Yep.
And if you don't, what? She can't sell it to anybody else. So my buyer has your property tied up. It's probably best just to get me out of here. Do you agree? So why don't you talk to your seller and call me back? Is that a risk management approach? Yeah, we had a deal in our office where the buyer gave the deposit up. Stupid. Because they sent a release in. The seller said, we're not releasing your money. So they said, okay, fine, we need to buy another house, so we'll give you $30,000. They walked away. It's terrible. You see, the problem with real estate is you're really practicing law without a license, which wouldn't be a problem if you were trained, but we don't train our people. Right? I mean, if you can be a paralegal and do legal things if you're legally qualified, the problem is we don't teach you how to do this. So anyway, but if you had that kind of situation, could you call Guy Berry?
Yes.
No, you can't, because you don't have my CDs.
Yes, I do.
Okay, but if you have my CDs, you can call me. Yeah, we do this all the time, by the way. It sounds like a crazy thing, but trust me, it works. Okay, what about number 11? Turn to paragraph 3H2. Here's what this means. The buyer has a loan contingency, right? They come in with a loan contingency. And then what happens is they really don't get the money. You know how on the down payment that's coming from Uncle Charlie in Hong Kong, it doesn't get here? Or mom doesn't gift you the letter? Or your stock doesn't sell? Or the escrow you were getting money from doesn't close, or all that thing? In other words, whatever here is on the down payment on page 1, you need to find out where that money is coming from. Because if you don't, if you look at 3H2, last sentence, it says buyer's contractual obligations to obtain and provide deposit, down payment, closing costs is not a contingency. What did I say a contingency was?
Get out of jail, to be private.
Yeah.
That's what I said it was. What?
Your right to walk away. This is specifically saying what? If it's because you don't have the money, you can't use that as an excuse.
Where does it say that?
Paragraph 3H2, second sentence.
And it's in bold.
And it's in bold.
Are not contingency.
Right, it's not a contingency. It means you can't walk. So the point is, when you have a client, you have a duty, I think, to say, where's the down payment coming from? And they're making some story. Just then turn to paragraph 3H2 and say, here's the problem. If you don't get it, you possibly lose your deposit. Because look, isn't it true, listing agents, that we look at the buyer's deposit and down payment as one of the bases for deciding which offer to accept?
Yes.
Right? So if it turned out not to be true, then they were being deceptive. Do you agree? They don't have the money. Because if you don't have the money in the bank, we just had this happen in our office where there was like a $1.2 million deal. This couple was buying this property for their son who was in Stanford, and they were buying this property. He was going to live in it and rent out the rooms. It was like $1.2 million in Palo Alto, or Los Altos, I forget which one. And it turns out that the money came from Hong Kong, then it went to San Francisco, then it came into escrow within 2 days. Boom, boom, boom. What's the problem? You ever heard of seasoning?
Yeah. Well, it has to be seasoned for 3 months.
6 months?
Yeah. Well, the bank said they at least would accept 2 months. The point is, they said, look, you can't close an escrow based on money bouncing around the United States. So the buyer went back to the seller and said, can you wait 2 months? In this market, what do you think he said? No. So guess what? He gave the buyer his deposit back.
Nice.
And resold it, probably for more. But did he know that when he released the deposit? I mean, can you see these are issues that matter because the contract's very complicated. Do you think maybe I should talk to my buyer about that when I have my meeting?
Oh, definitely.
Yeah. Are we talking about that stuff? We're not. Yeah.
But that's only to obtain a provided deposit, and closing costs are not contingencies. So it's kind of a iffy explanation there.
Not really. If you understand what a contingency is.
I guess I don't.
Contingency is the buyer's right to walk away.
Yeah.
This is saying if the reason you don't close the escrow is because of lack of down payment, lack of deposit, or lack of closing cost, it's not a contingency, you can't walk. That help?
Yes.
Okay. There's a great example of reading what it says and then saying what it really means, because that's what I tried to do on my CDs a lot, by the way, because there are some parts of the contract that aren't clear. Okay, buyer's closing, number 12. If a buyer wants to hold the buyer's deposit, this will tie the property up. We just went over that, remember? Yeah, if you've got a release, you're the king. A release is the secret. You can't sell this property to more than one person. And also, when you have backup buyers, you can't decide whether the buyer is out of contract or not. I mean, we've had many cases, many lawsuits where buyer number one doesn't perform or like he's late. And so buyer says, okay, listing agent says, you're out of contract, and backup buyer, you're in contract. Is that true? No. That buyer, the backup offer language, which is in the contract, says you have to get a release of the first buyer to the backup offer to be in first place. Questions on that? I mean, it's because we did our little dance a minute ago. I think you probably already got that one. You like my dancing?
Yes.
Okay. I don't know how people can sit still for all this time. Okay, here's why 2010 contract training class, if you will, matters, because the 2013 contract, which you have in front of you, has one change, is the only difference between the 2010. It's in paragraph 6E. So the whole 2013 contract had to be reprinted based on one paragraph. And look at paragraph 6E and tell me what that applies to. A new seller duty to disclose. 6E. Pipeline. What's that talking about? San Bruno. Right? So if you do an NHD disclosure now, you get that disclosure, right?
Yeah.
But they broke it out in the contract simply because that's the way the law got written. And by the way, tell your buyers that they're only going to disclose the major pipelines. Did you know that? They're not, every house has gas. The only difference, the gas line to your house is this big. The ones that blow up are as big as this room. That's the ones they're going to disclose. So if your client says, am I going to be near a pipeline, tell them that the only thing that report shows is going to be the major pipelines. Because we all are around gas, right?
Yeah. And it's not going to show exact location.
It's not going to show up, no. So you can be a quarter mile away, but who knows? I mean, I didn't know that the natural gas lines actually come from Texas. Did you guys know that? No. There are pipelines that run all the way from here to Texas.
Wow.
That's amazing to me. Underground somewhere, yeah. Wow. And they're this big, as big as this room. So, question, this worthwhile today?
Yes.
Good.
Thank you.
We're a little bit over. I apologize for that. I think we might have started a couple minutes late. Anyway, though, if you guys want the CDs, I'll do that now. And then I will hang around a few minutes to talk about questions you might have, specifics. But if you will either fill the form out or bring your business card, that'll speed it up. Okay? So let me get